Welcome to the deep dive. Our job here is to take complex, often overwhelming source material, articles, legal documents, transcripts, and really distill it down into an articulate, focused understanding. We try to give you the knowledge you need, complete with all the nuance and sometimes the surprising facts.
Then our mission today, well, it centers on one of the most pivotal events of recent American history, the killing of Breonna Taylor back in March 2020. This case really touches on everything, doesn't it? From the specific dangers of high-risk search warrants to these deep systemic fractures in police accountability, looking across both state and federal lines.
Yeah, absolutely.
So we'll meticulously unpack the timeline, the controversies surrounding that initial warrant, the really diverging paths of civil and criminal justice, and then the policy changes that followed.
Okay, let's jump in and unpack this. Setting the scene, Breonna Taylor's story, it really became this crucial element in the whole national movement for reform. So let's start with who she was. She was a 26-year-old African-American woman, a dedicated medical worker, an EMT, actually.
Right. She was employed full-time by University of Louisville Health.
And she was killed just after midnight, around 12:40 a.m., March 13th, 2020, right there in her own apartment in Louisville, Kentucky.
And the operation that night, it involved several officers, but specifically 3 from the Louisville Metro Police Department, the LMPD, were involved in the shooting itself. Jonathan Mattingly, Brett Hankison, and Miles Cosgrove.
Okay.
Now, Mattingly was actually struck by gunfire during the exchange, but later investigation confirmed that it was Officer Cosgrove who fired the fatal shot that took Taylor's life.
And Taylor wasn't alone, right? Her boyfriend was there.
That's right. Kenneth Walker was with her in the apartment.
So the crucial point, the thing that seems to have set everything in motion, was that moment of entry. It all kind of hinged on whether it was a no-knock entry or if they announced themselves, right?
Exactly. The warrant they got, initially it was a no-knock warrant.
Right.
Which, allows police to enter without warning if they think evidence might be destroyed or there's a safety threat.
But wasn't there some confusion about that?
There was. Reports indicate the orders were actually changed just before execution. Changed to a knock-and-announce warrant. Standard procedure.
Okay, so they were supposed to knock and announce.
Supposed to. But this change, or maybe the lack of following it, this is where the stories just completely collide, violently collide. The officers involved, they testified pretty consistently, actually, that they announced themselves loudly, repeatedly, police, before they use a battering ram on the door.
But Walker tells a completely different story.
Completely different. And it's not just him. Walker maintained he heard knocking, sure, and he said he heard Taylor ask, "Who is it?" But he was adamant, no announcement identifying them as police.
So in the dark, middle of the night, he thought they were being broken into.
Precisely. He thought it was a home invasion. He actually called 911 right then.
And what about neighbors? Did anyone else hear anything?
Well, that's crucial. Walker's account gets significant backup when you look at reporting, like from the New York Times. They interviewed, I think it was a dozen neighbors nearby.
A dozen?
Of all of them, only one neighbor, and this person was literally right upstairs, on the exterior staircase above her apartment. Only that one person claimed to have heard police. And they said it was just shouted once.
Just once.
Just once. Most other neighbors, they heard the banging, the ram hitting the door, and then, the gunfire. But not that critical announcement, police.
That distinction, intruders versus law enforcement, it changes everything, doesn't it? It flips the context entirely. If Walker thought they were intruders.
It becomes self-defense. Defending his home, defending Taylor, believing their lives were in danger, he fired a single shot. He stressed later it was a warning shot.
Aimed low, maybe.
He didn't specify aim, just called it a warning shot. But that single round hit Officer Mattingly in the leg.
Okay, and the police response to that single shot?
Immediate and devastating. In that chaotic, narrow hallway, officers fired back. A total of 32 rounds into the apartment.
32 rounds.
32. And sources describe it not as one long burst, but like 2 distinct flurries of shots, with maybe a minute pause in between. The amount of force in a residential apartment, it's just staggering.
32 rounds, you can imagine the damage.
Oh, absolutely. The reports detail bullets hitting pretty much every room. Living room, dining room, kitchen, the hallway where Taylor was standing, both bedrooms, just riddled.
And Taylor was in the hallway.
Yes, she was struck by 5 or 6 bullets in that hallway. She died right there at the scene.
And you mentioned 3 officers involved in the shooting, Mattingly, Cosgrove, who was the third.
Brett Hankison. And his actions specifically became a major focus later, legally speaking.
How so?
Sources detail that Hankison fired 10 of those 32 shots. But he fired them blindly, from outside the apartment.
Blindly? What does that mean?
He was shooting through a covered patio door and window, a sliding glass door that was covered, couldn't see inside clearly. He just fired 10 rounds into the apartment from the patio area.
Did those shots hit anyone?
No, actually. None of Hankison's 10 shots hit Taylor or Walker. But the act itself, firing without a clear target, without knowing what or who was behind those walls, that reckless nature of it later became the sole basis for the state's criminal case against him.
Okay, so that distinction is important. The sort of heat-of-the-moment return fire versus just firing blindly into a building.
Exactly. And that recklessness, that blind firing, it kind of serves as a bridge to maybe the most damning part of this whole thing.
Yeah.
The warrant itself. How did they even get to her door?
Right. The physical events were obviously tragic, but the search for accountability, it really pivoted quickly to the justification for the raid in the first place, the warrant affidavit.
Precisely. And this gets to the foundation of the whole operation. And honestly, it reveals a system, or at least this instance, built on some really flawed, shaky premises. First off, Breonna Taylor wasn't even the main target of this drug investigation.
Who wasn't? Who were they after?
The investigation was primarily focused on two men, Jamarcus Glover and Adrian Walker. They were suspected of selling drugs about 10 miles away from Taylor's apartment.
10 miles away. So what was the connection? Why raid her home?
That's the million-dollar question, isn't it? The link was tenuous. According to Glover himself, it was basically non-existent regarding actual drug operations. Taylor had dated Glover previously. That was the main link.
An ex-boyfriend.
Yeah.
Ugh.
And her address and phone number had apparently been used by him, but for things like bank statements, maybe mail. Police also said they saw a car registered to Taylor near Glover's suspected drug house at some point.
So a past relationship and maybe some mail. That was it. That was the basis for a no-knock raid on her home.
That seems to be the core of the justification presented for including her address on the warrant list.
But did Glover himself say she was involved?
Quite the opposite. And we have this from the source's recorded jailhouse phone calls, interviews later. Glover repeatedly, emphatically denied Taylor was involved in any drug trafficking, period.
Did he explain the connection at all? The mail, the car?
He did admit she held some money for him once, around $8,000. He described it as money he was saving. She was just holding it as a favor. But he stressed it wasn't drug money. She wasn't keeping drug funds there. She wasn't part of his operation.
And was she ever charged in his case?
Never. She was never a co-defendant. Which makes what prosecutors did next look, well, deeply questionable.
What did they do?
Sources revealed that after Taylor's death, prosecutors actually tried to pressure Glover. They offered him a draft plea deal.
Okay.
And this deal specifically required him to testify that Breonna Taylor was part of an organized crime syndicate.
Wait, they wanted him to lie after she was dead, to basically create a justification after the fact.
That's exactly what it looks like. An explicit attempt to retroactively manufacture a criminal reason for the raid that killed her.
Did he take the deal?
No. Glover rejected that draft deal. And significantly, that language about Taylor being part of a syndicate was removed from the final plea agreement he eventually took.
Wow. That just screams desperation, doesn't it? If you have to try and force the main suspect to implicate the victim after the fatal raid, it suggests the original justification was incredibly weak.
It points to a fundamental lack of confidence in why they were there. And that weakness goes right to the heart of it. The affidavit used to get the warrant in the first place.
The document presented to the judge?
Exactly. Detective Joshua Janes sought the warrant. Judge Mary Shaw approved it. And the key claim in that affidavit, the linchpin really, was that Janes alleged Glover was receiving drug packages at Taylor's address.
Okay, that sounds more concrete than just an old relationship.
It would be, if it were true. Janes claimed in the affidavit that this package delivery had been verified by a U.S. postal inspector.
Okay, so he's saying the post office confirmed drugs were being mailed there.
That's what he swore to in the affidavit.
And was it true?
Not even close. Completely false.
How do we know?
In May 2020, so about 2 months after the shooting, the U.S. postal inspector in Louisville went public, made a public statement, categorically denied Jane's claim, said point blank that collaboration never happened.
So the post office said, nope, we never told him that.
Exactly. And went further. The inspector stated their own monitoring of Taylor's address had concluded, and I quote, "There's no packages of interest going there."
So the central piece of evidence used to justify raiding her home was just made up.
It appears that way. It gets worse. Janes's own earlier statements contradicted the affidavit.
How?
He had apparently told internal investigators before the raid that a different police department unit had informed him only ordinary mail, like letters and flyers, was being delivered to Taylor's address, not packages.
So he likely knew the postal inspector hadn't confirmed drug packages, but he put that false claim in the sworn affidavit anyway.
That's the strong implication. He used a claim he likely knew was false to get the judge's signature on that warrant.
Unbelievable. And this fabrication, this lie to the court, this eventually became the focus for federal investigators, right?
It did. The Department of Justice, the DOJ, they focused squarely on this conspiracy to lie. That led to federal criminal charges. Not against the shooters initially, but against the officers involved in the paperwork, the ones who created the false justification.
Who specifically was charged?
The DOJ charged 3 officers who didn't fire shots that night: Kelly Gullett, Joshua Janes himself, and Sergeant Kyle Meany. They were charged with conspiracy, obstruction of justice, and civil rights violations.
And the core of the federal case was?
The core was that they conspired to mislead Judge Mary Shaw, the judge who approved the warrant based on false information, and then crucially, they tried to cover up that lie after the raid went tragically wrong.
And did those charges stick? Did anyone take responsibility early on?
Yes, one officer did. Kelly Gullett pleaded guilty relatively quickly in August 2022.
What did she plead guilty to?
She admitted to conspiring to violate Taylor's civil rights by lying on the warrant application and then helping write a false report afterward to try and cover up the initial lie. She agreed to cooperate with the feds.
So she's expected to testify against Janes and Meany.
That's the expectation, yes. Her guilty plea secured a factual admission, on the record, of the deliberate lie at the very heart of this tragedy.
But for Janes and Meany, the path wasn't as straightforward, right? There was a recent legal development that really complicates things.
Hugely complicates things. This is a really critical point about how the law distinguishes different kinds of responsibility. In August 2024, just recently, a U.S. District Judge, Charles Simpson, made a significant ruling.
What did he rule?
He dismissed 2 of the most serious felony charges against Janes and Meany, charges related to depriving Taylor of her rights through the unreasonable search that resulted from their lies. He reduced those specific charges to misdemeanors.
Wait, hold on. How can a judge rule that lying to get a warrant, which directly led to a fatal raid, isn't the legal cause of the harm? That doesn't seem logical.
It hinges on a tricky legal concept called legal causation or proximate cause, which is different from simple but-for causation.
Okay, break that down. But-for causation means?
But for the officer's lie, they wouldn't have gotten the warrant, wouldn't have been at Taylor's door, and she wouldn't have died. Simple chain of events. A causes B causes C.
Right. That seems clear.
But Judge Simpson focused on what happened at the door. He ruled that Kenneth Walker firing his gun even though he believed he was acting in self-defense against intruders was an intervening act.
Intervening, meaning it broke the chain.
In the judge's legal view, yes. He essentially ruled that Walker's shot disrupted the direct legal link between the officer's lie and Taylor's death. He reasoned that Walker's action transformed the situation from a warrant execution into a gunfight, and that gunfight, initiated by Walker's shot, was the immediate legal cause of Taylor's death, not the fraudulent warrant itself.
That feels incredibly problematic. So the legal system is saying the resident defending his home is the reason the officers who lied to get there aren't as responsible for the death that resulted.
That is the stark implication of that specific ruling. The judge concluded that while Janes and Meany are still charged with crimes like falsifying records and obstruction, meaning they definitely lied, that initial lie is no longer considered the proximate legal cause of the fatal violence.
And that has real consequences for potential penalties, right? Misdemeanors versus felonies.
Huge consequences. It significantly reduces the potential prison time and lessens the legal gravity connecting their fraudulent actions to the tragic outcome.
So even with clear proof of a conspiracy and a fabricated warrant, the legal system found a way to sort of cushion the fall for the officers who set the whole thing in motion.
It highlights this gap between perhaps more responsibility and strict legal causation standards in these cases.
And this complex legal landscape, the separation of the paperwork fraud from the physical violence, it perfectly sets up the next part of our deep dive. These really diverging paths of justice we saw play out, state, federal, civil, all looking at the same event through totally different lenses.
Absolutely. The accountability picture here is like a mosaic, with pieces that don't quite fit together smoothly. Let's start with the state criminal proceedings in Kentucky, which were notably limited in scope.
Right. The state Kentucky, they really focused their criminal case almost entirely on just one officer, Brett Hankison. And not even for shooting Taylor, but for endangering the neighbors.
Precisely. In September 2020, a state grand jury indicted Hankison. but only on 3 counts of felony first-degree wanton endangerment.
Okay, what does wanton endangerment actually mean in this context?
It means acting with extreme indifference to human life, creating a substantial danger of death or serious injury. But crucially, these charges were not for harming Breonna Taylor. They were specifically tied to those 10 shots Hankison fired blindly from outside.
The ones that went into the next apartment.
Exactly. Those bullets penetrated an adjacent apartment where a neighboring family sources say a man, a pregnant woman, and a child were sleeping. The state charges were solely about the danger posed to them.
And what about the other 2 officers who fired shots, Mattingly and Cosgrove, the one who fired the fatal shot? Any state charges for them related to Taylor's death?
None. The state grand jury declined to indict Mattingly or Cosgrove for Taylor's death.
What was the justification for that?
The Kentucky Attorney General at the time, Daniel Cameron, argued that their use of force firing back after Walker shot first was legally justified under Kentucky self-defense laws. Because Walker fired first, their return fire was deemed legally permissible by the AG's office.
So the state essentially said their shooting was okay because he shot first, but Hankison's shooting was reckless towards the neighbors.
That was the state's legal framework, yes, which effectively removed Taylor's death itself from the scope of the state criminal trial.
But didn't that grand jury process itself come under fire? Weren't there questions about whether the grand jurors even got to consider homicide charges?
Oh, absolutely. Huge controversy erupted almost immediately. 2 members of that grand jury later spoke out publicly, which is quite rare. They broke their silence to criticize Attorney General Cameron.
What did they say?
They claimed they were never actually presented with the option to vote on homicide charges against Mattingly or Cosgrove. They felt the prosecutors actively steered away from that possibility.
So they felt the decision not to charge for homicide was made for them by the prosecutors.
That was their assertion. It strongly suggested the AG's office had predetermined the outcome they wanted, focusing only on Hankison's shots into the neighboring unit. One juror even said anonymously that based on the evidence they did see, they believed the police were involved in a cover-up.
Despite all that controversy, the state trial against Hankison on just those 3 wanton endangerment counts went ahead. What happened?
It went to trial, and in March 2022, Brett Hankison was acquitted, found not guilty on all 3 state charges.
Acquitted, so the jury didn't think his blind firing endangered the neighbors.
The jury, based on the specific evidence presented and the legal standard for wanton endangerment under Kentucky law, reached a not guilty verdict. So, bottom line, the state criminal justice system delivered 0 convictions against any officer involved in the raid for any crime related to that night.
0 convictions at the state level, which makes the federal intervention even more significant, right? The DOJ stepped in with a completely different legal approach.
Completely different. The federal government basically bypassed the state's narrow focus on endangering neighbors and went right at the core constitutional issues, civil rights violations.
How did they frame that?
In August 2022, the DOJ charged Hankison again, but this time federally, for the unconstitutional use of excessive force. It's a charge often framed as deprivation of rights under color of law.
Okay, deprivation of rights under color of law. That sounds different from murder or assault. What does it mean legally?
It's a crucial distinction. The federal charge isn't asking, did this violate a state criminal law like assault? It's asking, did a state actor, like a police officer, using their official authority violate someone's constitutional rights? In this case, the argument was that Hankison violated Taylor's Fourth Amendment right to be free from unreasonable seizure, which includes protection against excessive force.
So the feds argued his blind firing itself was excessive force that violated Taylor's and Walker's constitutional rights, regardless of whether those specific bullets hit her.
Essentially, yes. The federal prosecutors argued that firing 10 rounds blindly into an occupied dwelling unreasonably endangered the occupants, Taylor and Walker, thereby violating their fundamental rights under the Constitution. It's about the officer's conduct under the color of law, not just the outcome of the shots.
That federal trial wasn't straightforward either, was it?
No, it was a bit of a roller coaster. Hankison's first federal trial ended in a mistrial in 2023. The jury just couldn't reach a unanimous verdict.
But the DOJ didn't give up.
Nope. They immediately announced they would retry him on the same charges.
And that retrial, that's where we finally saw a conviction.
That's the one. The retrial happened in October 2024. And on November 1st, 2024, the federal jury came back with a verdict. Guilty. Brett Hankison was found guilty of depriving Breonna Taylor of her civil rights.
That's a landmark moment in this case.
Immensely significant. Because even though his shots weren't the fatal ones, a federal jury concluded that his actions during the raid were unconstitutional. It proved that federal civil rights laws could provide an avenue for accountability when state criminal laws or their application failed.
But then came the sentencing, and there was another twist, wasn't there? Something about the Justice Department's recommendation.
Yeah, that was surprising and frankly pretty controversial. When it came time for sentencing, the DOJ itself filed a recommendation asking the judge for only 1 day in prison for Hankerson.
1 day after a federal conviction for violating civil rights in a fatal raid? Why?
Their reasoning wasn't fully public, but they basically argued time served, which was minimal, plus supervised release was sufficient. It drew immediate and widespread criticism from activists, Taylor's family, many legal observers who felt it minimized the gravity of the conviction.
Did the judge agree with the DOJ's light recommendation?
No, thankfully for those seeking stronger accountability. The federal judge rejected the DOJ's 1 day recommendation. The judge clearly viewed the crime more seriously. In July 2025, Hankerson was sentenced to 33 months, that's 2 3/4 years in federal prison, followed by 3 years of supervised release.
So a significant prison sentence, much more than the prosecution itself asked for. Okay, so that covers the complex criminal paths, state acquittal, federal conviction. What about accountability within the police department itself and through civil lawsuits?
Right. There's also administrative accountability, people getting fired, and civil justice, which often means monetary settlements. Administratively, action started relatively early. Hankerson was fired by LMPD back in June 2020.
And the reason given for his firing?
The department cited him for wantonly and blindly firing his weapon during the raid, highlighting his extreme indifference to the value of human life. So his own department fired him for the very actions this gay jury later acquitted him of criminally.
That disparity is stark. What about the other officers? Cosgrove, who fired the fatal shot, and Janes, who wrote the bad warrant.
They were also fired, but later, in January 2021. Cosgrove for violating use of force policies, and Janes for issues related to the warrant affidavit, basically for dishonesty.
Did they accept their firings?
Cosgrove appealed his firing, but his appeal was denied by the Police Merit Board. Janes also had his termination upheld. But then came another controversial development.
What was that?
Officer Cosgrove, after being fired by LMPD for his role in the shooting, was later hired as a sheriff's deputy in nearby Carroll County, Kentucky.
He was rehired as a police officer after being fired for a fatal shooting.
Yes. The sheriff there defended the hiring, pointing out that Cosgrove had never been criminally indicted for the killing itself. It perfectly illustrates that getting fired from one department doesn't necessarily prevent you from being hired by another, especially if there's no criminal conviction.
Wow. Okay, so administrative action was taken, but with mixed long-term results. Let's turn to the civil side, the lawsuits.
Right. This is where we see the earliest and arguably the largest form of financial accountability. Taylor's family filed a wrongful death lawsuit against the city and the officers involved back in May 2020.
And that settled relatively quickly.
Very quickly, especially for a case this complex. By September 2020, just 4 months later, the city of Louisville agreed to settle with Taylor's estate for $12 million.
$12 million? That sounds substantial.
It was, and is. Sources noted it was one of the highest settlements ever paid in the U.S. for the wrongful death of a black woman involving police. A landmark amount.
But settlements like that often come with caveats, right? Did the city admit they did anything wrong?
No. And that's the standard practice in these big municipal settlements. The $12 million agreement included language explicitly stating the city admitted no liability or wrongdoing. So they paid a massive amount to resolve the claim, but legally they didn't concede that the officers or the department acted unlawfully or negligently.
So financial compensation, yes. Admission of fault, no. What about Kenneth Walker, the boyfriend?
He also pursued justice through the civil system. Remember, the initial criminal charges against him, attempted murder of an officer, were eventually dismissed with prejudice.
Meaning they couldn't be refiled?
Exactly. Permanently dropped. After that, Walker filed his own lawsuit against the city and officers for the trauma and violation of his rights. In 2022, he reached a $2 million settlement with Louisville.
And wasn't there a countersuit at one point? Didn't Officer Mattingly sue Walker?
Yes, that happened. Officer Mattingly, who was shot in the leg, filed a civil suit against Walker in late 2020, alleging assault and battery, seeking damages for his injury.
What happened with that suit?
It lingered for a while, but Mattingly voluntarily dismissed his lawsuit against Walker in May 2023. So that legal battle ended without a judgment.
Okay, so let's recap the outcomes. A huge civil settlement for the family, another for Walker, but no admission of fault from the city. Administrative firings, but one officer gets rehired. A state acquittal for reckless endangerment. Federal felony charges related to the warrant drastically reduced. And finally, a federal conviction for Hankerson on civil rights violations, leading to prison time. It's a real patchwork.
A very complex mosaic, exactly. And this patchwork of outcomes, this collision of different systems trying to grapple with one event, it leads directly into the long-term impact. What changed? What were the systemic reforms and the cultural reverberations?
Because the public outcry was immense, things had to change, right? Starting within the LMPD itself.
Absolutely. The pressure was intense. Police Chief Steve Conrad, who was already facing criticism, was fired in June 2020. This wasn't just about the Taylor raid. There was another incident shortly after where officers involved in a different fatal shooting failed to activate their body cameras, which just fueled the fire.
So, new leadership. Did that lead to policy changes?
It did. The LMPD implemented mandatory body camera usage for all sworn officers. And importantly, they significantly changed their internal procedures for how search warrants, especially high-risk ones like no-knocks, are requested, reviewed, and executed.
And Louisville didn't just stop at internal policy changes, they put it into law.
That was a huge step. The Louisville Metro Council acted swiftly and unanimously. In June 2020, they passed Breonna's Law.
Named specifically after her. What did it do?
Two main things, both critical. First, it completely banned the use of no-knock warrants within Louisville Metro limits, period, no more. Second, it established strict body camera rules for warrant service officers now have to turn them on 5 minutes before executing a warrant and keep them on for 5 minutes after.
That body cam rule seems directly aimed at preventing disputes like the "did they announce themselves" question.
Precisely. It aims to create a clear, objective record of the entry process and the immediate aftermath.
Did this push for reform stop at the city limits?
No, it spread. At the state level, Kentucky Governor Andy Beshear signed a bipartisan bill in April 2021. It wasn't a total ban like Louisville's, but it partially banned no-knock warrants statewide.
Partially banned. How?
It significantly restricted their use, generally limiting them to situations involving violent crime where there's clear evidence announcing police presence would create an imminent threat of death or serious injury. It raised the bar considerably compared to just protecting potential drug evidence.
So, state-level restrictions, too. And what about federally?
There was definitely momentum at the federal level as well.
Yeah.
Several pieces of legislation were introduced in Congress, like the George Floyd Justice and Policing Act, which included provisions, and the Specific Justice for Breonna Taylor Act.
What were they trying to achieve?
The main goals were to prohibit no-knock warrants in federal drug cases nationwide, and to use federal funding as leverage, basically incentivizing states and local departments to adopt similar bans or restrictions, trying to make the changes systemic across the country.
Beyond the laws and policies, the cultural impacts, it felt massive. This case really became a touchstone in the broader conversations happening around race and policing.
Absolutely central. It happened concurrently with the surge of the Black Lives Matter movement in 2020. And Breonna Taylor's story specifically highlighted the vulnerability of Black women to state violence, an aspect that sometimes gets less focus in the broader narrative. The phrase, "say her name," became this incredibly powerful rallying cry, demanding visibility and justice.
And we saw that reflected everywhere, from protests to, well, magazine covers.
The cultural response was huge. Oprah Winfrey's decision to put Breonna Taylor on the cover of O magazine was unprecedented. First time in 20 years, Oprah herself wasn't on the cover. And they put up those 26 billboards around Louisville, one for each year of her life, demanding the officers involved be arrested and charged. That was a powerful statement.
And it carried into awards shows, sports.
Yeah, Regina King at the Emmys wearing the shirt with Taylor's face, Uzo Aduba also honoring her. George Clooney, being from Kentucky, spoke out about his shame over the initial lack of homicide charges. Lewis Hamilton using the Formula One podium. It permeated popular culture in a way few cases do.
But that intense spotlight, that simplification, maybe arrest the cops, did that cause any issues?
Well, some observers noted that. While the visibility was crucial, the specific, often complex demands for different types of accountability sometimes got boiled down online into slogans or memes. There was some concern, according to sources, that this could overshadow the deeper systemic issues about warrants, training, and oversight that the case revealed.
And the political fallout even reached the judge who signed the warrant.
It did. Judge Mary Shaw, who approved Janes's warrant based on that false information, she faced intense scrutiny. And when she ran for re-election in November 2022, she lost.
And she blamed the Taylor case.
She directly attributed her loss to what she termed false narratives surrounding her role in signing the warrant. It shows that even judicial figures weren't immune to the political and public consequences stemming from this case. There was a tangible price paid.
So, looking back at everything we've unpacked, this deep dive really lays bare the sheer complexity of achieving accountability in these kinds of policing cases today. You have the state criminal system essentially justifying the officer's lethal force, resulting in acquittal.
Right. Then you have the federal system stepping in, focusing on constitutional rights and managing to secure a conviction, albeit not for the killing itself, but for the excessive force used during the raid. That demonstrates a different pathway through civil rights statutes.
Meanwhile, the civil justice system delivers this huge financial payout, providing compensation for the family, but crucially, without the city admitting any legal fault.
And then layered on top of all that, you have the administrative firings, showing internal accountability, but even that's undercut when an officer is rehired elsewhere. And finally, the legislative system responding with concrete policy changes, like banning the no-knock warrants that started the whole chain of events.
It's just so many different outcomes from the same incident.
It truly is a synthesis of these disparate results. It shows that the quest for justice rarely follows a single, clear road. We've traced the lie that initiated the raid, the chaotic violence that ended a life, and the various legal and political systems that tried, with varying degrees of success, to process the aftermath.
We saw Hankison acquitted by the state for endangering neighbors, but convicted federally for violating Taylor's rights. We saw the officers who allegedly orchestrated the whole thing via a fraudulent warrant have their most serious federal charges reduced because of a legal ruling about intervening acts.
That collision of outcomes, that difference between how state law, federal civil rights law, and civil liability function, that really is the enduring legacy here.
It leaves you wondering, what is the most effective route?
And that, I think, leads us to the final reflection point for you, the listener, to really mull over after hearing all this. Considering that traditional state criminal justice, the system we normally think of for murder or assault charges, proved effectively inaccessible for holding officers accountable for Taylor's death itself in this instance. What does that disparity really tell us about how rights are protected or not protected in America today? When we're seeking accountability for state violence, what seems to be the most reliable path forward? Is it pushing for massive civil settlements, even if they lack admissions of guilt? Is it relying on federal oversight and robust enforcement of civil rights laws? Or is the most practical impact found in narrowly targeted legislative reforms, like banning specific high-risk police tactics like no-knock warrants? Which lever of change, civil, federal, legislative, truly holds the most promise for safeguarding citizens from these kinds of systemic failures in the future?